You died even though the one doesn't.
There's nobody.
Madam Chair, you are live.
All right, thank you very much. You have reached the House Energy and Digital Infrastructure Committee for our afternoon meeting to walk through the Global Warming Solutions Act. So, as is our practice, and I believe we're being joined by House Environment Committee. Is that correct, Chuck?
Correct.
Are they here?
I am admitting them now.
Okay, great. We're going to very quickly introduce ourselves. Representative Kathleen James, Manchester.
Scott Campbell from St. Johnsbury.
Richard Bailey, Lamoille 2.
Chris Morrow, Weston.
Michael Southworth, Caledonia 2.
Christopher Howland, Rutland 4.
Dara Torrey, Washington 2.
Graham Klepner, Chittenden 13.
Laura Savellia, Wyndham 2.
Hello, House Environment. Okay, we've established the connection. We typically ask folks in our committee room who are here to observe to just briefly identify themselves and who they're representing today. So,
good afternoon, committee members. My name is James Duffy. I'm a fiscal analyst for the Joint Fiscal Office.
Thank you.
Olivia Goebel, intern for Representative Celia.
Maggie Maury, intern for Representative James.
Erin Ahern, intern for Representative Ann Wilson.
Molly Mahar with the Vermont Skiers Association.
Thank you. Chair Sheldon, would you all like to introduce yourselves, or are you just lurking today?
Don't know if we can. And we get too much reverb, so we're going to just say hi. Thank you. We'll lurk.
Thank you for joining us. All right, we are turning the table over to Ellen. If you could please introduce yourself for the record.
Ellen Tchaikovsky, Office of Legislative Counsel. I am here today to give you an overview of the Global Warming Solutions Act. I'm going to share my screen and do a PowerPoint presentation, but I believe it has also been shared on your committee page, so you can follow along at home, or if you have your iPads, you can do that. And I'm going to share, and just so you know, I hate having a laptop in front of me when I'm testifying, and I'm not very good with PowerPoint, so I'm sure this is going to be fine. But if it isn't, sorry, I'm a paper and pencil person. All right, there we go. Okay, so I'm here to talk about the Global Warming Solutions Act, aka the GWSA. So the Global Warming Solutions Act was passed in 2020. It was Act 153. I did not draft it. And so I was not the original drafter. So some of the things that happened during that time, I don't know a ton about the rationale of the decisions. But I suspect there are people in this room who may know some of the conversations that were happening and intent that happened at the legislature. And so I will do my best to inform you on the law and what I know about it and what's in the statute and what's been going on, but there will be some things I can't fill in. And at some point you may want to hear from the Climate Council and the Climate Action Office at ANR, who have been working on this actively since it's been passed. So what it did basically was it changed existing state law that established greenhouse gas emission reduction goals. It changed those goals to requirements or mandates. Those requirements were set to match the Paris Agreement, which was an international agreement as part of a conference by the United Nations. 196 countries signed on to the Paris Agreement to reduce global greenhouse gas emissions, the purpose of which was to hold the increase in the global average temperature to well below 2 degrees Celsius above pre-industrial levels, and pursue efforts to limit the temperature increase to 1.5 degrees Celsius above pre-industrial levels. So what the bill also did was establish the Climate Council to develop the Climate Action Plan, which created a list of actions as recommendations that the state could adopt to reach the required reductions. This is just my overview slide, by the way. I'm going to go into detail on the rest of this. The statute directs ANR to adopt rules to help meet those reduction requirements It also establishes the private right of action or the citizen supervision that allows the public to sue ANR if they don't adopt rules to meet the reductions or if the emission reductions aren't met. And the progress on all this is measured as in the Vermont Greenhouse Gas Emission Inventory and Forecast, which is published by ANR. So, getting into the specific language that was adopted in the statute from the GWSA. So first, it amended Title 10, Section 578, the greenhouse gas reduction requirements. And this statute previously existed, but what it originally said was that these were goals, and so it changed them to requirements. So Vermont shall reduce the emissions of greenhouse gases from within the geographical boundaries of the state and those emissions outside of the state caused by the use of energy in Vermont as measured in inventory pursuant to Section 582. Section 582 is the statute that establishes and directs ANR to adopt and publish the Vermont Greenhouse Gas Inventory and Forecast, which I already mentioned. So the specific numbers on all this are first, the reduction has to be not less than 26% from 2005 greenhouse gas emissions by January 1, 2025. And that's pursuant to being part of the Climate Alliance to achieve the goals and objectives of the Paris Agreement. So some of this information is reflected in that statute, which I just mentioned. I cut out some of the rest of the text for 2 and 3, but really what you need to know is it's 40% reduction from the 1990 greenhouse gas emissions by January 1, 2030, and 80% from 1990 levels by January 1, 2050. You will notice that January 1, 2025 has already come and gone. So we'll talk about that a little bit more. Those numbers are hard to contextualize. So really short at the bottom there is by 2025, the Vermont emissions have to be 7.3 million MMT.
Billion tons of carbon dioxide
It's actually
equivalent.
million metric tons carbon dioxide equivalent. Sorry, I was going to get there. 7.3. Then by 2030, we're going down to 5.4 million metric tons, and by 2050, 1.171. So you will. That all is very hard to visualize. So this is the chart that is in the most recent greenhouse gas emissions inventory and forecast to help you sort of visualize what we're talking about. The most recent forecast, inventory and forecast came out in July of last year, so 2024, and the data was current through 2021. If for some reason I am using the wrong one, I apologize, but I was looking for the data this morning and I hope I found the right graph, but it's currently through 2021, where they found that currently Vermont is at 8.28 million metric tons as of 2021. And in order to meet the first requirement, the state needs to get to 7.3 million metric tons as of January of this year. So what you can see here is that in July of 2024, ANR had the data through 2021. That means there is a time lag on when the data is available, and that makes sense, right? Because a year has to fully finish, and then all of this information needs to be compiled and analyzed in order to establish this number. So ANR operates and creates this data, this information on a time lag, and that will come up later. But so as of 4 years ago, Vermont was at 8.28, and the state needed to get to 7.3 by this January.
Excuse me.
Oh, sorry, Representative Sealy.
The chart is depicting which sectors have contributed to reducing emissions. Is that what we're seeing?
So yes, there's a lot of information in this graph, and if I put the link on there if you want to look at the sections all around, and there's a ton of information in this report. But yes, the colored bars do reflect what emissions come from which sectors. And so part of the climate action plan does dictate that there needs to be specific recommendations based on each sector's specific emissions. So you can see from this graph that purple is the lowest bar, and purple is transportation, which is the largest, it's the sector that has the largest amount of emissions in Vermont. Happy to have A&R come in and speak. This is A&R's chart.
We saw it this morning.
Oh, you did? Yeah. So I didn't make it, so I can't answer detailed questions on it.
I'm confused by, and I guess I missed it this morning, the fossil fuel industry being listed on there.
I can't answer.
Okay.
It
seems, well, I'm sorry that I missed that this morning. It seems very confusing.
I don't think we saw that this morning. Did we? Anyway.
Yes,
Did we?
yes, we
Okay.
saw, but you'll notice that there's no red on the vertical bar chart.
Right.
Well, it's very, it's this.
Way at the top.
But transportation is measuring fossil fuel emissions in the transportation sector. Residential is measuring fossil fuel emissions in the residential heat sector. That's why I'm confused. Like, what does that mean, fossil fuel industry?
Right, and so it's a little bit awkward that I stole someone else's chart, but I wanted you to have the visual of what we're talking about in the Global Warming Solutions Act as far as the markers of where you need to get in the reductions.
So why don't we put a pin in that question to ask A&R since it's their chart. I do have one question, and then sounds like we'll circle back to A&R for questions about the chart. But I'm curious to see, essentially level here for 20 years. Does the 1990 date to our first attempt to enact goals?
No.
That's just a date.
There is a reason why that date was chosen, and I can't answer that.
That's fine.
It's the baseline year for the Paris Agreement.
That's right.
Yes, I'm
Baseline
not
for
sure, I'm
Paris.
not sure why, but I do. Yes, it does. It is one of the dates that's referenced in not only that, but other Global Warming Solutions Act.
Well, let's let you keep going because we're gonna have plenty of chances to talk about this chart with A&R since it's their chart. Okay.
So,
Yeah, I'm sorry. Just a quick question. Could you tell me what makes up the GHG? What gases or whatever it is what exactly are we trying to?
Is that an A&R?
So it is defined in statute. I don't have it in front of me, although we can get it for you right now. It's in Title 10, Section 552, I believe is the definition of greenhouse gas. And so it is a defined list of,
Okay.
Yeah. So there is a defined list in statute. I can get it to you.
Okay, thank you.
Yeah.
Thank you, sorry.
No, that's okay. I'd love to see that too. So, all right.
All right. So the next up, the law established the Climate Council. So this is a group that is 23 members. 8 of them are ex officio, meaning by virtue of their office. So there are 8 heads of agency that are part of the Climate Council. Then there were 8 members appointed by the Speaker of the House and 7 members appointed by the Committee on Committees. If you want to see the full list, it is in Section 591, and 23 members, it's a long list. So they serve 3-year terms, staggered 3-year terms, so that there are appointments that expire each year. They are required to have at least four subcommittees to look at specific issues, and those are the Rural Resilience and Adaptation Subcommittee, the Cross-Sector Subcommittee, the Just Transition Subcommittee, Agriculture and Ecosystem Subcommittee, and they are allowed to form other subcommittees to look at other issues if they would like, and I do believe that they have formed a couple other subcommittees, and they're allowed to appoint non-members to staff those. So they're allowed to appoint members of the public to sit and staff those other subcommittees if they want. And so you may want to hear from the Climate Council on that other work that they're doing. But the formation of these subcommittees was to support and develop information on the specific elements that needed to go into the climate action plan. Because what is required in the climate action plan is quite a long list of things. So the Climate Council was formed. They started their work at the end of 2020, beginning of 2021, and they had until December 1, 2021 to adopt the first climate action plan. Here it is. It is quite large. Mine is all tabbed up and highlighted up. And then thereafter, they are supposed to update the plan every 4 years. And so July 1 every 4 years. So there is an update to the plan due out in July of this year, 2025. The plan is supposed to include strategies and programs to achieve the greenhouse gas emission requirements, strategies and programs that build resilience and prepare the state to adapt to the current and anticipated effects of climate change. They have to have means to measure the state's progress towards meeting the greenhouse gas emission requirements. And they also are supposed to give guidance to the General Assembly on necessary legislation that is needed to adopt the programs that would achieve the greenhouse gas reductions. Additionally, they provide status reports to the General Assembly every January 1st on what they did in the prior year's activities. And so they did already submit, I believe they already submitted their report, just detailing what they've been working on. So you can get that on your reports page. Additionally, here are some of the things that the council has to do. They have to identify, analyze, and evaluate strategies and programs to reduce greenhouse gas emissions, achieve the state's reduction requirements, and build resilience to prepare the state's communities, infrastructure, and economy to adapt to the current and anticipated effects of climate change, including creating an inventory of all existing programs that impact greenhouse gas emissions and their efficacy, evaluating and analyzing the technical feasibility and cost effectiveness of existing strategies and programs, and new strategies and programs that are based on emerging scientific and technical information, analyzing each source or category of greenhouse gas emissions, and identifying which strategies and programs will result in the largest greenhouse gas emission reductions in the most cost-effective manner, identifying public and private financing strategies to support the transition, evaluating and analyzing existing strategies and programs that build resilience, and new strategies and programs to prepare the state's communities, infrastructure, and economy to adapt to the anticipated effects of climate change. They also have to identify the means to accurately measure the state's greenhouse gas emissions and progress towards meeting the reductions, including the publishing of the emissions data in a timely manner, the effectiveness of the specific initiatives as set forth in the plan and updates to the plan, the effect of climate change on the state's climate, wildlife, and natural resources, and existing resilience to the state's communities, infrastructure, and economy, and progress towards improving resilience. They're also supposed to provide guidance to ANR on the form, content, and subject matter of the rules that ANR is required to adopt in order to reach the greenhouse gas emissions. So you've given the council a very long list of things to do, and that's why they have these subcommittees to focus and dig in on some of these things. Additionally, I did want to point out that I think when the committees were working on this, they tried to incorporate looking at cost effectiveness as much as possible, as well as looking at resilience, particularly for rural communities, as things that they wanted to make sure were highlighted in the plan. All right, so section 592 establishes the requirement for them to publish the Vermont Climate Action Plan. So as I said, the first one was due December 1, 2021, with updates every 4 years after. The plan must address the strategies for reducing greenhouse gas emissions from the specific sectors, which include transportation, building, regulated utility, industrial, commercial, and agricultural sectors. So the plan is actually organized that way. Each sector has a list of recommendations for what are the top recommendations in order to achieve the most greenhouse gas reductions in the most cost-effective manner. And so also they have to prioritize the most cost-effective, technologically feasible, and equitable greenhouse gas emission reduction pathways, provide reductions that reflect the relative contribution of emissions from the different sectors. And so as you saw in the chart, transportation has the largest amount of greenhouse gas emissions compared to the other sector. The building thermal sector is traditionally second, and then the other ones are a lot smaller compared to those two, which are our biggest sources of emissions. They have to minimize negative impacts on marginalized and rural communities and individuals with low and moderate income, ensure that all regions of the state benefit from the greenhouse gas emission reductions, support economic sectors and regions of the state that face the greatest barriers to emission reductions, especially rural and economically distressed regions and industries, support industries, technologies, and training that will allow workers and businesses in the state to benefit from the greenhouse gas reduction solutions, support the use of natural and working lands to reduce greenhouse gas emissions, sequester carbon, and increase resilience, and maximize the state's involvement in interstate and regional initiatives and programs designed to reduce greenhouse gas emissions and build upon national, state, national, and international partnerships and programs. And so again, the plan shall form the basis of the rules adopted by ANR. If no plan is adopted or if no update is adopted, ANR has the authority to proceed adopting rules in order to reach the greenhouse gas reduction requirements.
We might be getting to this. I'm trying to just make sure I have a handle on accountability and who's supposed to be doing this work.
Mm-hmm.
So the Climate Council researches and publishes the plan.
Mm-hmm.
And then it is then the responsibility of the Agency of Natural Resources to adopt rules to achieve that plan.
Yeah, sorry, I guess I didn't say this clearly. So this report is a set of recommendations.
Right.
The council itself is not empowered to act, but they created this list of recommendations. The recommendations are directed to the General Assembly, as well as the Agency of Natural Resources, the Agency of Agriculture, Food and Markets, and I believe there's some towards the DPS as well, Department of Public Service. And so some of the things are brand new programs, and that is the General Assembly has the only authority to adopt brand new programs. However, as I'm about to talk about, ANR is granted authority under this law to adopt rules to achieve the greenhouse gas emissions based on recommendations that are in here.
Okay, so to make sure I'm sorry to go back over this again, I just want to make sure. So the Climate Action Plan is a set of recommendations, ideas, suggestions. And then different agencies and or the legislature could take action. There are different bodies that would have the ability to try to, we could pass a bill. Agency of, you said Ag could do some things, but the primary responsibility for moving this work forward and making sure that we're meeting our goals and adopting rules to make sure that we're following the law, that rests with ANR.
Yes.
Great. That's something I've been wanting to clarify. So, Representative Plepner?
Thank you. I would also add that, as noted, the law, the enforcement mechanism is that individuals and organizations in Vermont have standing to sue to compel action to meet the reductions.
I was going to say, I'm guessing we're moving in that direction. I don't know.
Yeah, that's the last part of this. Yeah.
Great. Thank you.
Yes. So, so the last section, or not the last section, the second to last section spells out the rules that ANR needs to adopt. And so this is text from the statute. It's not the full statute. That's why it says not verbatim. But I tried to, because it's a pretty long one, so I just wanted to have the pertinent information on this slide. But if you want to look at the full text, it is in section 593. So the Secretary of ANR shall adopt rules pursuant to the Administrative Procedure Act consistent with the Climate Action Plan. So there is the first directive that they have to adopt rules consistent with the plan. ANR shall develop a detailed record containing facts, data, and legal and scientific technical information to establish the reasonable basis to believe that the rules will achieve the state's greenhouse gas reduction requirements. So yes, ANR is the primary agency tasked with helping the state achieve the reductions. And then the rest of the statute is a timeline that establishes by when ANR needs to start adopting these rules. In subsection B is the first deadline, which has already passed. So the plan came out December 1, 2021. By December 1, 2022, ANR needed to adopt and implement rules consistent with the plan to achieve the 2025 reduction requirement. Did they? They adopted a rule that's part of California's Clean Air Act waiver, the Clean Car Rule, which updated the requirement for fuel efficiency in cars. And so they did that in December of 2022 to be in line with the update that California had also adopted at that point. So we can talk more about that at a different hearing, or you can hear from ANR about that, but that was the first set of rules that they've adopted under the Climate Action Plan. Section C is another important section of this. It says that the Secretary shall conduct public hearings across the state concerning the proposed rules, and they have to conduct these hearings in portions of the state in areas and communities that have the most significant exposure to the impacts of climate change, including disadvantaged, low-income, and rural communities and areas. And so typically in a rulemaking, only one public hearing is required on a set of rules, but this does say that they have to conduct multiple public hearings, and they have to be in multiple places around the state, not just at the office in Montpelier. And that's to make sure that there's information sharing with the public and feedback from the public on the things that they are experiencing under climate change. So then subsection D is the next deadline.
Representative.
Sorry.
Yeah.
And that is for each of the
Yes.
additional deadlines.
In the rest of the deadlines under here, it does reference that they have to comply with the public hearing requirement in C. Yep. So D is the next deadline, and that one just passed in July of 2024. And so that directive was to review and, if necessary, update the rules to ensure that the 2025 reduction requirement is achieved. And in performing that review and update, the Secretary shall observe the requirements of C with the public hearings. Next, E, July 26th. Again, the Secretary needs to review and potentially update. So adopt and implement rules consistent with the updated plan that will have come out in July 1, 2025, in order to achieve the reduction required by January 1, 2030.
And I'm sorry, no.
Yep.
D,
D.
Did that happen? Were the rules updated?
The Secretary issued a letter to the Climate Council saying that she performed a review and determined that it was not necessary to update the rules. And so, the Secretary issued a letter to the Climate Council describing the review that she did. I haven't reviewed it recently, so I don't know the exact wording she said. There has been a lawsuit filed asking whether or not the review was, we'll get into that. So
the review in 2024 said we're on track. From the agency said we're on track.
The agency did say that they were on track, yes. And we can talk in a moment more about the lawsuit. But yes, so then there's a 2026 rule deadline. There is additionally more rulemaking deadlines in F. So every 2 years between 2026 and 2030, there's another review and, if necessary, update the rules to meet the 2030 deadline. And then again, they have to have the public hearings associated with that. G is for 2040. So the Secretary shall adopt rules consistent with the plan to achieve the 2050 reductions. And then in H, not less frequently than every 2 years between 2040 and 2050, review and, if necessary, update the rules to achieve the 2050 reduction, again complying with the hearing requirements of C. And then with I, after 2050, the Secretary may establish alternative reduction mechanisms once we get past that 2050 deadline. So that might include offsets for greenhouse gas emissions. Down in J, if the council fails to adopt the plan or update the plan as required, the secretary has to adopt rules. So she shall adopt rules and implement rules pursuant to 3 VSA Chapter 25, which is the Vermont Administrative Procedure Act, to achieve the greenhouse gas reductions. K then says that nothing in this section limits the authority of other state agencies if they have authority to limit greenhouse gas emissions. So this doesn't affect any other rulemaking authority that exists out there. And then the last one is subsection L, and this is an interesting one. So the General Assembly may repeal, revise, or modify any rule or amendment to any rule, and its action shall not be abridged, enlarged, or modified by any subsequent rule. So in order for the Secretary of Agency of Natural Resources to have this authority to adopt rules, the legislature had to delegate that authority. But the legislature is the supreme lawmaking body and therefore has oversight of any rules that the agency issues, and therefore has authority to repeal, revise, or modify any of the rules. And so if for some reason the agency came out with rules under this section that the legislature had concerns about, the legislature could directly modify those rules via a bill. And once you took that action, the agency could not then change the rules back. So you have that authority, you maintain that authority, even though you've delegated some of it to the agency.
I just have a comment, and then we'll go to Rep. Campbell. I just want to make sure I am realizing retroactively that I believe this is the first time we've had a member of Legislative Council in to give testimony.
Oh, yeah?
Yeah, so apologies, belated realization. So Ellen is a member of Legislative Council. She is a nonpartisan attorney who has expertise in this area of statute. So our questions today should be involving this area of statute, where Ellen is a nonpartisan lawyer who gets this section of statute. So if we have questions about what A&R has done, what the Climate Council has done, what progress we're making, those are really not appropriately directed at Ellen, whose job here is to provide us with, again, nonpartisan review of the statute. So I just want to make sure folks know that we've got plenty of places to direct those questions, but not to our esteemed nonpartisan attorney who's walking us through a law.
Great, and so some of that information I will have and be able to provide you just basic information on some things that have happened. But also, I was watching some of the Climate Council hearings originally, but I haven't in a few years, and so I don't know. I'm not up to date on all the things that they have been doing. I know that they are working on an update to the plan that's going to be due out this summer. But if you want the most up-to-date information on what they've been working on, including what some of their recommendations have been, hearing from the council as well as the A&R Climate Office is a good idea.
We are absolutely going to do that. I just wanted to make sure folks understood, and I didn't want to draw you out onto thin ice. Representative Campbell.
Sure. On the last point that you made, Ellen, about section L there, subsection L, that is really sort of obvious, isn't it? Isn't it redundant to add that? It may perhaps clarify, but it's just the General Assembly may do all these things, may repeal, revise, or modify any rule at any time for anything at any time. Is that correct?
Yes, but I think the last part of that sentence is important. I think generally I was not the drafter of this statute, but I think generally the drafter of this statute working for the legislature was attempting to be as clear as possible about what specific options were available to the General Assembly and when. And so even though something is usually universally understood, sometimes making it clear heads off lawsuits.
Okay, so that was
sometimes being redundant hurts. But this was a brand new statute. being very clear, I think, was the intent, so that no one tried to
Right.
see if there was a loophole.
Okay, I just wanted to
Yeah.
clarify that.
Yeah.
Thanks.
Mark?
So this is based originally on the Paris Accord, is that where we started? Not based, but I mean, that was.
Yeah.
So from a legal point of view, now that, you know, the Paris Accord, the goal was 1.5 degrees Celsius. Depending on what data set you pay attention to, we've basically, trailing 12 months, we've hit that. Does that have any legal effect on this? No.
I want to say
I wouldn't think so, but
probably
I
not.
would just.
There's only one reference in the statute to the Paris Agreement itself, but the rest of the statute stands alone. Yeah.
Yeah.
All right, and then finally,
Yes, sorry, Representative Bailey. Sorry.
Maybe I'm either, I went over it too early or too late, but the state can be, A&R can be sued by not achieving that. I mean, what about if companies come in and say, well, these are just too stringent and they need to be lowered? Can it go both ways or just go one way?
so generally, as a lawyer, anyone can try to bring a lawsuit on anything. I don't see where in the statute they'd be able to challenge that. The citizen suit provision that's in section 594 is specific to failure. So generally, if someone attempts to sue the state over a law being too strict, that isn't really a remedy. That isn't really a cause of action. They might try to challenge based on how it was adopted or if it's unconstitutional. And so I'm not sure what kind of argument they'd try to do based on how strict it was. They could, based on something that it would depend on what the rules actually did say, or what statutory provisions say, like the clean heat standard. And so it would depend on the specifics of that. Creative lawyers can always try to challenge things, but based on this citizen suit provision, no, it's based on failure. So yes, this is the provision that I think I get the most questions about, which is section 594, which should establish the cause of action, or AKA the citizen suit provision. So there are two prongs. There are two options. In A, any person, I'm sorry if this is a little small, but it's on your website. Any person can bring an action based upon the failure of the agency to adopt or update the rules based on the deadlines that are in 593. The action is brought pursuant to Rule 75 of the Rules of Civil Procedure, and it's brought in the Civil Division of the Superior Court of Washington County. So Rule 75 is an existing rule under the court rules, and it allows for there to be, anyone can bring a lawsuit under rules, or they could try to bring a lawsuit under Rule 75 for government inaction or failure to act by a government agency. And so sometimes, people ask if, I thought the legislature directed an agency to do blank. What can we do about this? Well, you could try to bring a suit under Rule 75, which allows the court to review if an agency has failed to do something it was directed to do. And so there's some language in Rule 75 on how the lawsuit should proceed under that rule. But the statute supplements that by providing additional details like a timeline. So in subdivision 2, it goes on to say the complaint shall be filed within 1 year after the time in which the secretary was required to adopt the rules. So the July 1 date just passed. If someone wanted to bring a lawsuit, they would need to do that by July 1, 2025. But the next sentence also goes on to say that they have to give A&R 60 days notice of the alleged violation before they actually file the suit. And so someone who thinks that A&R has violated the law has to at least give them notice that says, hey, I think you failed to adopt the rules. you have a response before I actually file the lawsuit? And then 3 goes on to say what the remedy is. So if the court finds the secretary failed to adopt or update the rules, the court shall enter an order directing the secretary to adopt or update the rules. If the court finds that the secretary is working on it, if they find that that the secretary is taking prompt and effective action to adopt and update the rules, the court may grant the secretary a reasonable period of time to do so.
So I just want to highlight for the committee, I was on the, Representative Sevilla and I were on the committee at the time when we talked about this, and this particular section got a lot of conversation. And the important parts of this to me were that the cause of action wasn't throwing open the door to lawsuits. It was actually intended, and I think does, very clearly channel a cause of action to a specific timeline, a specific reason, and a specific remedy. That does not include anybody can sue for any reason and collect damages. It's about channeling what people can bring a cause of action for and under what circumstances. So that was the purpose of adding this clause or this section to the bill. Further to add.
Yes. So the Global Warming Solutions Act, when it was enacted in Massachusetts, there was no such specificity, and there was kind of a protracted court case where the court needed to determine what the remedy might be, including any kind of financial situation. So this was intended to narrow what the court and give direction to the court. So there was not
a related question. I was not on the committee, so this is a useful walkthrough for me. I want to make sure I understood something that you said, which is that Rule 75 of the Vermont Rules of Civil Procedure, setting aside the defining bullet points that the legislature added, any citizen of Vermont could sue any state agency at any time, with or without this, for a perceived failure to do their job.
Yes.
So this didn't create the right for a Vermonter to sue ANR or sue DMV or sue. That right exists and will continue to exist and is in our statute. This was an effort to say you can sue ANR under these specific circumstances and only these specific circumstances under the GWSA, and the remedy can only be, hey, you have to do the thing. It's not money.
Yes, but C down at the bottom,
right,
in both instances does allow for the award of attorney's fees.
Right.
So I'll get there in a second. Okay. But yes, generally, no, not just you don't just get to like make money off that. It is
okay.
Narrowed to directing the secretary to update the rules. So the other, in addition to whether or not ANR updated the rules, under B, any person can commence an action alleging the rules adopted by the secretary failed to achieve the greenhouse gas emission reductions. So again, bring it in the civil division of the Superior Court, and again, the complaint shall be filed within 1 year after the Vermont greenhouse gas emission inventory forecast published indicates the rules adopted failed to achieve the required reduction. And again, they have to give 60 days notice. And so as I started talking about before, there's a time lag on the forecast and when it comes out, and so it probably will not be coming out this year. It will be coming out sometime in the future. And then from 1 year after the date of the publishing of that report shows that the emission reduction wasn't achieved, a lawsuit can be brought then. And then the remedy, if the court finds the rules adopted by the state are a substantial cause of the failure to achieve the emission reductions, the court shall enter an order remanding the matter to the secretary to adopt or update the rules that achieve greenhouse gas emission reduction requirement consistent with the chapter. If the court finds that the secretary is taking prompt and effective action to comply, the court may grant the secretary a reasonable period of time to do so. So this does give the court some discretion to say, okay, the secretary did adopt rules, but it wasn't the reason why the state failed to meet the requirements. Maybe there was, a pandemic, or maybe there was some, bigger cause, something unexpected, a natural disaster that would have led to there being a spike in emissions, and the secretary's actions weren't the cause. So it does give the court the ability to look at that as well. Wrapping up in C, as I just mentioned, the prevailing party or the substantially prevailing party. So if it's the plaintiff, if it's the person who brings the lawsuit, the citizen or group, they shall be awarded reasonable costs and attorney's fees, unless doing so would not serve the interest of justice. Or if it's the defendant, which would be A&R, if A&R wins, they may be awarded reasonable costs and attorney's fees if the action was frivolous or lacked a reasonable basis of law or fact. So if for some reason, so that's always a concern, is if someone is actually bringing a frivolous lawsuit. And so like an example of that was if the greenhouse gas emissions inventory came out and said that the 2025 reduction was met and someone brought a lawsuit anyway, that might be considered a frivolous lawsuit because the data actually showed that it was met. But if there is a reasonable dispute, which is what the courts do look like, is there a reasonable dispute between the parties? There would not be awarding of the costs. And then lastly, nothing in this act limits the rights of other remedies available at law, including the Vermont Administrative Procedure Act, in case there was any defect in adopting the rules. Okay. So that's the really quick version, because I know you all have to get to the floor soon.
We do, but we have, I think, a final question.
Just one quick one.
Yeah.
If the secretary determines that the goals are unachievable and needs to can she change them, or does that have to be a legislative change?
That would have to be legislation. Yeah.
Thank you. Thank you.
Yeah.
All right, so that was a very quick overview. I did find a nice chart that Luke had made that had sort of said, the legislature is adopting this statute. It has reduction requirements. There's an arrow then that leads to the creation of the Climate Council, who then leads to the creation of the plan, which then leads to the adoption of legislation and rules to meet the reductions.
Okay.
So you set up a series of changes in here, a procedure in order to reach this is what is a very big task of having these reductions.
Okay, so thank you so much, and for your testimony, I think we'll make sure that we post your PowerPoint, the 2021 Climate Action Plan, the thing that you just said, the flowchart thing.
Oh, I don't have it. I mean, it was.
Oh, shoot. Anyway,
it was in the 2020 record when I was trying to look back.
Oh, okay. I think that's, I guess, then just the 2021 Climate Action Plan and your PowerPoint. Oh, and let's post in the folder, Jack, the full GWSA, not the summary. Are we good? Yes.
A letter from Secretary Moore saying that we didn't need to update we were making adequate progress.
Great.
Oh, yeah, that's the flag I was going to mention. I think you already know the lawsuit has already been filed by the Conservation Law Foundation, alleging that the secretary has missed the subsection D deadline, which was this July 1, 2024, to adopt rules.
So we will need to get that letter, but I don't know if that's not your responsibility to get that letter. Maybe we'll get that from the secretary. And then we have a January 15th Vermont Climate Council report to the General Assembly. But as I said, we'll start gathering all this stuff from the right people, but everything pertaining to your testimony. Thank you so much, Ellen.
Yep.
Thank you.
Okay, we're adjourned.